Hello everyone, good morning. Welcome to today's webinar. We are delighted to welcome our senior compliance expert, Ms. Pramila, having 25 years of practical experts in handling compliance frameworks across industries. In today's webinar, the session will provide valuable insights into recent labor law developments, compliance challenges, and key updates under the Code on Social Security. So without any further delay, over to you, Pramila ma'am.
Yes, good morning all. Is my voice audible to all?
Yes, audible.
Fine, yeah.
Can hear you.
Fine. I'll share my screen. Is it visible to all? The screen is visible to everyone?
Yes.
Yeah, please. Yeah. Thank you. Okay, so today we are going to see a glimpse of recent labor law changes with the key focus on social security rules. Okay, so before that, I just want to introduce about the relativity. Okay, so relativity, what we do actually. Okay, so we have a experience of serving the customers of more than 17 years with above 200 clients, and we are located services in 16 different cities and 5 countries. And roughly, approximately, we handle about 1 lakh of payroll records in a month and over 12 lakh of transactions per quarter, and that too with accuracy rate of 99.4%, with a client retention of 99.69%. On top of it, we are ISO certified company. And few of our enterprise clients include MaxLinear, Toyota, and Nutanix, and mid-sized clients include Exmo, Vertical, and Peyoda. So what we do, what service we do is like right from payroll processing, compliance, TDS compliance, labor law compliance, and HRMS tool. And we have a compliance tool also, and we provide HR consultation and compliance audit also we provide. So what is payroll processing? What are the services we offer under payroll processing? Payroll processing, we provide payroll management, payroll compliance, and employee self-service tool. And we manage payroll reimbursement and expenses management. And we do provide consultation for payroll and audit also we do. And we provide a legal registers, and even we provide customized standardized reports as per the client requirement. And we do provide help desk services also. So under payroll compliance, we have PF, ESI, PT, and labor welfare fund remittances, and all the statutory filings. And if need, we provide consultation also, and we do provide audit also. All this we do with the help of a smart operator tool. And under tax compliance, we have Q4 filings and validation of investment proof for the ITR filings and issue Form 16. And whenever any notices or demands is being issued by the government officials, that is being handled. And we do provide audit of TDS, and we do provide help desk services also. So under labor law compliance, we provide maintenance of registers and documents under various labor laws. And whenever requirement of any annual filings or half-yearly filings, we do provide support in that. And if in any case, during any inspections or any notices is being issued, we provide support in handling those notices and demands. And regarding registrations and amendments, if required any support services for getting any registrations under the CLRA Act, we provide help in getting registrations. And whenever there is any changes, we go help you out in going for any amendments. And we do POSH compliance also and apprenticeship also. And whenever there is any update in the legal changes, means we keep posting all those updates to the clients. And we have a HRMS tool which handles right from onboarding till exit. All these can be managed with this HRMS tool, which includes core HR management, payroll, attendance, performance management, and all the business expenses can be claimed. All these can be handled in the HRMS tool. And we have a compliance tool also. So this compliance tool helps you to manage the entire compliance management and even the liaising activities and query management. So suppose in case if any notice is being issued, it brings transparency where the status of the notice stands and any progress is being, this can be tracked within under the compliance tool. And the query management, employees can post the queries in the tool, and this can be addressed within a specified business timeline. And we have the auto alerts also, which reminds you of the compliance at the specified timelines. And we do provide support in auditing your establishment and provide consultations. And this tool carries a knowledge hub wherein all the latest legal updates and amendments will be keep posted. And this will help the client to enforce that, what do you say, that the changes on time. So apart from this, we have other add-on services which includes POSH compliance, Shops and Establishment Act compliance, and code on wages consultation, which is right now it is happening, and HR consultation and advisory. And we provide extensive support in implementing the Apprenticeship Act requirement and the CLRA compliance and audit and salary restructuring as per the new wage code. And DPDP advisory, the digital data protection advisory we give to the clients. Okay, so the recent hot happening is the labor code implementation. You can make use of the relativity's expertise in implementing the labor code changes. Okay. In today's agenda, we are going to see a brief introduction of about the recent introduction of the central rules for all the labor codes, and what would be the key changes in the social security. Okay, so we are going to focus only on the social security rules, which brings in key changes, and few other key updates in the labor law for few states. And finally, we have the question answer session. You can ask the questions, you can post the questions in the chat box. Okay. So I request all the participants to participate in the poll. So this will help us to understand from which organization you are coming from and with the headcount strength. So all this will help us to provide a further, what do you say that, a webinar presentation which helps you out in getting a knowledge on the recent updates and changes. Okay, so I could see people from headcount, employee strength of 1 to 100 with the 28%. I mean, even people from 500 to 1,000 headcount strength. I think equal number of people from this headcount strength are participating. And department, I could see people from HR mostly from HR, they are participating. Yeah, good. 64% to people are from HR and payroll and compliance. And people from which company? I think I could see more number of people from other sector, maybe probably from manufacturing 12% and ITS 38%. Good. So I request all the participants to please participate in the poll. I could see only 68% participating. We have more number. Yeah. So I think people from others, when he say others, I would like to understand what is the other sector. And I think 50%, almost 50% of the people from other sectors, apart from this IT and manufacturing. And I think equally people, I think the IT people from ITS, we have more number from ITS, I think 40%. Yeah, and mostly people from HR background are participating, almost 70% of HR. And yeah, organization strength, we have a maximum people from organization strength of 500 to 1,000, they are participating. Yeah, good. Thank you all. Thank you for this participation. Okay, so we'll just have an introduction of what is that we are going to see. So if you could remember, okay, so Ministry of Labor and Employment, they have notified all these 4 labor codes last October. Okay, so last October 2025, all these labor code was introduced. The code on wages, the code on social security, the code on occupational health, safety and working conditions, and the code on industrial relations. Okay, so all these codes was introduced last November, and hopefully every one of you is taking steps towards implementation of these codes. Like, for example, we have to revisit the definition of the wages, and as per the redefinition of the wages, we have to implement the gratuity, the EL encashment, and we have to revisit the eligibility for ESI and PF contributions has to be made accordingly. So few of these changes, hopefully everyone would have started implementing all those changes. So rules. Okay, so the labor ministry, they have introduced the central rules. Okay, so before that, in December 2025, they notified the draft rules wherein all the public stakeholders, all the stakeholders and the public, common public, they can share their feedbacks and their suggestions. So government has taken all these feedbacks and suggestions and they have fine-tuned the rules, central rules. Okay, so and finally, after this, soon after the election from West Bengal and TN, they have introduced this no rules, central rules for all these four codes. Okay, so the code on wage central rules 2026 and code on wage, code on social security central rules, and code on occupational health, safety and working conditions central rules, and the code on industrial relations central rules. All these are 2026, and they all these rules have been notified on 8th May. Okay, so 8th May, they have all these rules have been brought inside. So here, the applicability of the central. Before going into details of the subjects, it is very much viable to understand to whom all these central rules is applicable. Okay, so all these public sector undertakings or the subsidiaries or any autonomous bodies which is controlled by the central government or for matter of corporation or any other authorities which is being established by the central government and which falls under the purview of the central government, they are being, all these establishments, including the banking, insurance, telecommunications, airport, railways, and when we say railways, it includes metro railways also, mines, oil fields, all the major ports, all these central government undertakings, they have to adhere to these central rules. Okay, so when coming into the private establishments, okay, so whichever the establishments they are being located in more than one state and the union territories, they have to adhere to the central rules. Okay, so maybe few of you may be located, your organization may be located in more than one state. Please make sure that you adhere to the central rules. Okay. So today we are going to have a focus on the Social Security Rules 2026. Okay. So why Social Security Rules means few of the provisions is applicable for all the private sectors. Okay, irrespective of whether they fall under the purview of the state government or the central government. Few of the provisions under the Social Security, it is applicable for the all the private sectors. Okay, for all the establishments. So in this slide, if you could see this national emblem, you can see, okay, so when you see this emblem, you have to understand that the central provision is applicable, okay. So coming to this slide, okay, PF and ESI applicability, okay, all you may be all aware of how the ESI and PF is applicable, but I just want to reinstate that PF, if you have 20 or more employees, PF is very much applicable, okay. ESI, coming to ESI, when you have 10 or more employees, if the act is, the provision is applicable, we should not say act, we have to say as a provision. The provision is very much applicable. And in case if you have a hazardous activity which is happening inside the establishment, even one employee is there, the a provision is very much applicable. Okay. So once we understood that the provision of ESI is applicable, we have to get the establishment registered under the portal. Okay. So you may be aware of the Shram Suvidha portal. So if the establishment is found to be applicable of these provisions, the employer has to get themselves registered in the Shram Suvidha portal in Form 1, and in return you will be receiving the registration certificate in the Form 3. Okay, so all those establishments which has already being registered or already complying with the provisions of ESI, they can simply go and update in the portal. Okay, all your registration details, all this can be updated in the portal. So once that has been done with, whenever the employer communicates with the department, they have to make sure that they quote the registration number for each communication. Okay, so to employer, all the applicable these provisions wherever it is applicable for all those establishments, they have to make sure that they get themselves registered under the Shram Suvidha portal and get the registration details. Okay, and registration of the employees. Once with the employer or the establishment, they recruit any new employee, okay, they have to fill in, and if they found that they are eligible under the ESI provisions, means they have to update all those details in the portal. Okay, see, for example, they have to fill in all the employee name, their Aadhaar card number details, okay, and in return, they will be provided with a temporary insurance number, which is valid for 30 days period. And in case if the recruited employee is already an insured person who have the insurance number, means they can simply enter the date of appointment in the portal. Okay, so simple what the employee has to do is they have to update the employee details, whoever is found eligible for the ESI. Okay, so if he is a new employee, it is the employee's responsibility to create the insurance number. And if any new employee, they have already IP, means they can simply write the date of appointment, so that they have to keep the data updated. Okay. And coming to contribution for the disabled employees. So a few organizations, they recruit physically challenged employees in the organizations. Okay. So in that case, the government is giving some concession. Okay. So before that, we need to identify whether the employee fall under the purview of definition of the Disabilities Act 2016 and the National Trust Act 1999, which speaks about the autism, cerebral palsy, mental retardation, and multiple disabilities. So people, whoever we, as an employer, we are recruiting any disabled person in the organization, we have to make sure that whether they fall under the purview of this definition of these two acts. So if they fall under this purview of this definition, means the government is saying that for initial 3 years period, no contribution can be made by both the employer and the employee. Okay, so initial for the 3 years period, they don't have to go for the contribution of ESI. If at all, if the employee is eligible for ESI, they don't have to make the contribution. So what the employer has to do is they have to keep track of this time period, whether the 3 years period has been over or not. Okay, so that is very important. And coming to insurance benefits, okay, so here we could see that the section 2 and 33, subsection 33 and clause E speaks about the dependence benefit, okay, the dependent parents. So this section under the Social Security Code. So when you go and find out the definition of the dependence parents, it says that even for the female employee, it includes the parent, father-in-law and mother-in-law. These two can be included under the dependent parents. So these dependent parents, they can draw the benefit from the ESI. Okay, but before that, we have to make sure that the income for these parents should not cross beyond 14,000 per month. Okay, so if it goes beyond 14,000, they are not eligible to receive the dependent parents benefit. Okay, so the employer has to make sure that before clubbing the dependent parents for benefit, they have to make sure that they get the valid proof to ensure that their income is within the threshold limit. Okay, and funeral expense benefit. Okay, so as you know, ESI is providing the funeral expense for the employees' death. Okay, so in case of death, they are providing the funeral expense. So that benefit was 15,000 previously, but now this has been changed to 20,000. So whoever is incurring the expenses, either it may be a legal hire or the dependents or a person who incurred the that funeral expense, they are being provided with the cash benefit of 20,000 as a funeral expense. So that was regarding ESI. So we have to understand the key changes which has happened with the ESI. Okay, coming to gratuity. So gratuity, as you know, the people who have completed for a regular employment under their regular employment, who have completed 5 years of service, they are very much eligible for the gratuity at the time of exit. The reason may be resignation or a termination from the employee side or a retrenchment or whatever may be the case, or it may be a death also. So at the time of exit, if they have completed 5 years of service, they have to be provided with the gratuity benefit. Okay, and coming to fixed term employment. Okay, so there are people are coming with this concept of having a fixed term employment contract. Okay, so if the at the time of expiry of this contract or at the time of exit of this contract, If the employee has completed 1 year of service, they are eligible for the gratuity payment. Okay, so this is to ensure that whoever is being recruited as a fixed term employment, they receive equal benefit like as a permanent employee. Okay, so that is the essence of bringing this fixed term employment for gratuity eligibility. Okay, if you could see the symbol, okay, so I think you saw the national emblem symbol. If you see this symbol like a flag, a building over the flag, flag over the building, if you could see that this is, you have to look out for the state government notification. Okay, so the gratuity nomination soon after when the employee joins any organization after completion of 1 year of service, and within 90 days of period they have to file the nomination. Okay, so this can be done all digitally. Okay, though no manual record is required, this can be done digitally. And while providing the nomination details, they have to provide the Aadhaar card details of all those nominees. Okay, so at the time of filing the nomination, if they didn't have any family and subsequently they have acquired the family, means they have to file a fresh nomination once they have acquired the family. Okay, so it is very much important. And if in case the employee cannot sign, or if you can say that they are highly not literate enough to sign, means they can go in for thumb impression. Okay, so they can take the thumb impression of the employee, provided there should be two witness for that. Okay, and those two witness also should sign that nomination. Okay, so once they have filed the nomination, a duplicate copy with along with attestation from the employee side, that has to be handed over to the employee. Okay, and compulsory insurance, a gratuity should always be with the, mandatorily should be there with the insurance. Okay, so the gratuity insurance has been made mandatory. Earlier it was not so. Few states like Andhra Pradesh and Karnataka, they had a gratuity insurance. Okay, compulsory insurance, but now this has been made mandatory, so we have to look out for the state government notification. So appropriate state establishments, they have to look out for the appropriate state government's notification for this compulsory insurance scheme. Okay, and coming to gratuity fund. Okay, so now a few of establishments, they have their own gratuity fund. Okay, so and that should be an approved gratuity fund. And these what do you say, that the graduate trust is being exempted from having a gratuity insurance. Okay, they don't have to mandatorily have this gratuity insurance, they are being exempted from these provisions. And who all can go for having this, they can create their own trust, means establishments having 500 or more workers, or the employees or the persons, sorry, we should not say as a workers or employees, a persons, 500 or more persons, they can go in for creating a gratuity fund. Okay, so all this with the taking the consent from the major representation of the employees or the workers, they can go in for forming this gratuity trust. Okay, so we have to look out for the state government notification for the compulsory insurance. So coming to maternity. So maternity, I think we have to switch from the current practice of the what do you say, the intimation of the of submitting the application for the availing the maternity benefit. Okay, so form 11 is the maternity form, wherein if any female employee is on maternity period, means they can submit this application. In this application, they can provide the nomination details with their Aadhaar card number details. Okay, so suppose in case of any untoward happenings, means they can provide the benefit to the nominee. Okay, and in case if the employee cannot have the benefit directly, means they can nominate. Okay, so in that form 11, they have to provide all those details. Okay, so once after the delivery of the child, or in case of any medical termination, or for a matter of pubectomy, they have to, or for extended illness arising out of the delivery, they have to submit the medical certificate from the registered medical practitioner. That is in form 10. Okay, and in case of death, okay, in case of death also, this form 10 has to be produced. Not mandatory that only form 10 certificate has to be produced. You can take the certificate from the village administrative officer, or even the authorized officer from the municipal corporation, and you can produce the death register extract also. So in case of any death of the mother or the child, okay, so this is valid. Okay, so in that case, the benefit, once they have give it to the nominee, either by the employer or the authority. They can get the attestation in the form 11 itself. You can find the second part 2 carries the receipt of the benefit. Okay, so that you can get the attestation from the nominee or the employee saying that I have received the benefit, maternity benefit from the employer. Okay, so why the better maternity benefits is being provided by the authority instead of employer. Okay, in case there is any doubt arise, like a nominee. Okay, if the employer has a doubt about the nominee, means they can hand over the better maternity benefit to the authority. Okay, so from the authority, this is being dispersed to the right person. Okay, so while doing this, the employer has to make sure that this the transferring of this benefit happens within 2 months period. Okay, not beyond that. In that case, they have to pay the penalty for it. And duration for the nursing breaks. It is mandatory that all the employer should give the nursing breaks for the mothers who have returned from soon after from the delivery. Okay, so this nursing breaks, you can provide 2 breaks with a duration of 15 minutes time. And in case if the that the distance between the crèche and the workplace is quite far, means extra 15 minutes a buffer time can be given for the employee to go and come back. Okay, so this nursing breaks should be along with the rest interval. Okay, so it not that we have already provided rest interval by extra nursing breaks. It's not like that. Along with the rest interval, we have to, as an employer, we have to provide 2 nursing breaks with the duration of 15 minutes time, and we have to give a buffer time of extra 15 minutes for the employee. Okay. So guidelines for having the crèche facility. Okay, so if 50 or more employees, I would say persons, if 50 or more persons are there, when you take that 50 head count, we have to make sure that we include the contract labor also while taking the head count of 50. Okay, so we have to make sure that if we have 50 or more persons are there, it is the ultimate responsibility of the principal employer to provide the crèche facility. Okay, so the rules has brought in the guidelines how the crèche facilities should be. Okay, so if the crèche should not be beyond 1 kilometer radius from the working place. Okay, so we have to make sure that the crèche is within the 1 kilometer radius. Okay, and the building should be safe and rain proof, and it has to provide adequate accommodation for all the kids which has been there in the crèche, and proper adequate ventilation should be there, and sanitary conditions should be perfect and should be clean. Okay, and they have specifically mentioned that each kid should be provided at least 10 square feet of the floor for the child. Okay, so we have to see, we have to make sure if the number of kids is increasing, means we have to increase the we have to take we have to provide additional space area for the kids. Okay, and all the crèche should have the play area for the kids to play. Okay, so all this play area should be adequately fenced with. Okay, and when we look into the crèche working hours, it should correspond to the working hours of the employees. For example, there are n number of factories running all 3 shifts, so it means that the crèche also should be there for the corresponding working hours of all these 3 shifts. Okay, so it is the responsibility of the employer. And who has to handle this crèche? Under whose custody the crèche should be there? Okay, it should be under the custody of a female employee who has been provided with the certification with the midwifery qualification, or either that lady should have been trained in the crèche. Okay, as a crèche attendant, she has to be trained. Okay, so the crèche should be in charge of the women who possess this qualification and experience. Okay, and in case if there is more than 10 number of kids inside the crèche, means for every 10 kids, one caretaker, or we can say as a ayah, to take care of all those kids. Okay, and this crèche should be provided with sufficient number of cots, the bed sheets, the bedspreads, the blankets, the pillows, and the toys to play with. Okay, so all this has to be adequately provided. When we say adequately, please make sure that if the number of kids is high, proportionately the number of toys, the cots, everything should be increased. Okay, and there should be a suitable area should be there for the new mothers to feed their baby. Okay, so these are all the things which we have to take care as an employer. And hygiene and services, the crèche should be provided with the bathroom facilities, the wash basins, the soaps, the towels, all should be in clean condition. Okay, so what we have to do is you have to maintain a log for this. Okay, so whether this is being cleaned regularly at regular interval of time. And the crèche also should have a kitchen attached with that. So the kitchen is to make sure that they provide a wholesome refreshments, drinking water facilities, and the milk. Okay, all this has to be provided to the kids over there. Okay, and the first aid facility should be there. Okay, so a first aid box should be there, and this should be under the control of the person who knows the how to handle the first aid. Okay, so these are all the basic guidelines which a crutch has to be adhered to. So the employer has to make sure that they adhere to all these very basic minimum guidelines while providing this crutch facility. Okay, so in case the employer may feel that if we could join together and provide a crutch facility, common crutch facility for multiple establishments, yes, you can go ahead, have a common agreement. You can provide a common crutch facility to all those employees from the different establishments. Okay, you can have a common agreement and you can provide that. In spite of all these things, if you could not able to provide the crèche facility, it means you can go for providing a crèche allowance. Okay, this is also, the act is very lenient in that perspective. Okay, the employer, they can provide a crèche allowance of rupees 500 for all those kids which whose age is within 6 years period. Okay, and a maximum for 2 kids you can provide the crèche allowance rupees 500 per month. Okay, suppose in case this exemption is not strict, I mean this provision is not strictly adhered to, provided if it results in multiple births at one single delivery, we cannot deny that what do you say, that allowance only for 2 kids and not for the rest other. Okay, so in case of multiple births, this limitation is not allowed. Okay, so here you could see the symbol. Okay, that means you have to look out for the state government notification. Okay, so we have to look out for the state government rules also. But the point here, what we have to understand is all the state government rules should be over and above the facility which the central rule is providing, and not less than the central rules provide. Okay, so the thing is, essence, what you have to understand this, these are all the very basic minimum requirement to provide the crèche facility. Okay. Disciplinary action at the time of maternity period. Okay, so if there is any gross misconduct during the maternity period, earlier the act was not, there is no such provision. The employer cannot take any disciplinary action when the female employees is during the maternity period. Okay, so now this rule, the Social Security rule and the act has brought in what do you say, that giving some leniency towards employer. Okay, so in case of any gross misconduct during the maternity period, the employer can take a disciplinary action. Okay, so for example, if there is any destruction or what do you say, that a damage of goods, employer's goods, means they can go in and take action, disciplinary action. Okay, and in case that employee has to ensure that they adhere to all the safety guidelines, they have to wear the safety personal protective equipments, but they have failed to do so, means this can also be called for taking a disciplinary action by the employer. Okay, and co-working, manhandling with the co-workers. Okay, any physical assault of the co-workers, maybe a co-worker or it can be a supervisor also. In that case, they can go for taking an action against the employee. Okay, and for committing any criminal offense and being convicted by the court of law. Okay, in that case, they can terminate the employees also. Okay. And in case of theft, when we say theft, it's not only the physical property, it can be an intellectual property also. So in that case, if the management feels that it is a gross violation of the what do you say, that's what intellectual property means, they can go in for taking a disciplinary action, and they can also remove the employee from the employment. Okay, so all this has to be proved properly. Okay, so that is the what do you say, that responsibility of the employer to prove. So this is a central provisions rule which is mandatorily applicable for all the establishments, irrespective of whether they come under the purview of the central government or the state government. Okay, so this Social Security Act, Labor Code, they have exclusively provide benefits for the social security from the unorganized sector workers and the gig and platform workers. Okay, so that is a huge welcome from the unorganized sector employees. And what is it exactly they have to adhere to? Okay, so please look at the simple. This is from the central rule, so it is applicable. So the unorganized employees are the workers from the unorganized sectors. It can be a gig and platform workers. Okay, so what they have to do is they have to go in, they have to register themselves in the e-shram portal as an unorganized worker. So they have to provide all the relevant details like Aadhaar card, where they are located, all these details, address proof, all these details they have to go in, take themselves registered in this portal, and return they will get or what do you say, that an ID, okay, digital ID. So they can make use of this digital ID for availing the benefits. Okay, so as an aggregator, who is aggregator? By this time, everyone should have been more familiar with the term aggregator. Aggregator is nothing but the platform owners. Okay, so the online e-commerce platform owners, they are being defined as an aggregator. So this aggregator has a responsibility. So they have to submit all the worker details, whoever is joining their organization. So this has to be their website, or their should be have an interface with the government portal. So whenever there is an employee joining, means it has to be synced with the portal. So here the aggregators also should look out for the state government notification while getting registered for the state government portal. See, for example, if you see the Karnataka government, they have introduced a separate act for the gig and platform workers, the Karnataka Gig and Platform Social Security and Welfare Gig and Platform Workers Welfare Act. Okay, so it was introduced in 2025, and under this act, they have this separate insurance scheme for the gig and platform workers. So they have started remitting the fees. Okay, so what is the fees? It's the social security fund amount that is being deposited by the aggregators towards the fund. Okay, so from this fund only the social benefit will reach out to the gig and platform workers. So what we have to do is, as a private establishment who fall under the definition of as an aggregator, we have to look out for the state government notification for the getting themselves registered in the portal. Okay, so once that has been registered, it is the employer's responsibility to update whoever the employees they have to keep on updating in the portal. So we have to look out for the notification from the state government. And filing the annual returns, it is applicable for everyone. So for whoever the establishment, this gratuity and maternity benefit is applicable, it is the responsibility of the employer to file an annual return. And this return is submitted in the application form number 23, and should be submitted every year on or before 28th or 29th of February. Okay, and they should be filed in the central government portal. And in case if any establishment is being closed, or it has been handed over, or it has been sold to somebody else, means all these things, this has to be again this has to be the return, this the details has to be submitted in the returns. Okay, irrespective of the deadline to submit the returns, immediately whenever this kind of changeover happens, or any unexpected abandonment of the establishment happens, means this has to be filed as a return within 30 days time of that such incidents. Okay, so it is a responsibility of the employer to do so. Okay, so employment information and monitoring. Okay, so currently we have the practice 20 or more employees are there, means we have to notify the vacancy to the employment exchange. Okay, so what changes has happened after the rules has been introduced? So when we go through this central rules, they have clearly mentioned that currently the employment exchange officers has been converted as a, or being considered as a career centers. Okay, so if you remember, it is a responsibility of the employer to ensure that they notify the vacancies to the career centers. So these career centers are approved agents or the approved centers wherein the employer has to notify the vacancies. So currently, after this rules has been introduced, the employment exchange and the center and the regional levels is being considered as a career centers. Okay, so they have people who have branches, or the establishments who has who are located in more than in one state, means they can go in for central career centers to notify their vacancies. Okay, so if any vacancy is there, means they have to notify within 15 days time to the regional career centers. For central career centers, within 40 days time, they have to notify these vacancies to these career centers. Okay, so once they have shortlisted and selected, means they have to notify the result of the what do you say, that the filing. Okay, I mean, how many candidates have been selected, or they have been selected or not. All the result has to be again intimated to these career centers within 30 days from the date of selection. Okay, so the thing is, we have to look out for the state government notification. The state government also can notify the career centers at the regional level. So at the regional level, we have to intimate to the all these career centers. So we have to look out for the state government notification for the career centers. So what records we have to maintain? As an employer, we have to file an annual return, that is employment information return in Form 24. Okay, sorry, Form 26. So it has to be filed annually on or before 31st of March every year. Okay, so what details they have to file means they have to provide all the list of employees, their occupation details, what vacancy they have filled in the last year, how many vacancies they had, and how many they could able to fill, and how many they could not able to fill those vacancies, and how many vacancies they expect to come across in the coming financial year. All these details have to be captured in this return, and they have to be filed. Okay, so establishments locating in more than one state, they can go in for central portal, and establishment is who is located in one specified state, they can go in file in the regional career centers to file this annual returns. Okay, so again, we have to look out for the state government notifications. So with that, we have seen that what are the few key changes which we have to make sure that we comply with the social security central rules. Okay, so and few key changes we have to look out for the state government notifications. Okay, so with that, we had a recap of what all the changes the central rules has brought in, and what all the things we have to look out for the state government notifications. So now we are going to see few key labor changes which has happened for Tamil Nadu and Karnataka. When we say recent changes, means this recent changes has happened between the January 2026 to May 2026. Okay. So Tamil Nadu government, we'll first have a look at the Tamil Nadu government's key notification. So the Tamil Nadu government has given a recent minimum revised wage notification, which is effective right from April 1st. Okay, so when we look into the BSDA revised for the shops and establishment, we could see that 7,353 per month. Okay, and this is being estimated based on the consumer price index, which is 183 points. Okay, and this notification has been given for the 70 different scheduled employments. So you can go through this notification. So while comparing with the other similar sectors, you can see that shops and commercial, so manufacturing, cinema industry, and hotels and restaurants. So of these, when you compare, you can see that maximum it goes for the soap manufacturing sector with the 12,014. Okay. And one more thing, you can specifically, you would have come across this notification of submitting an annual combined annual returns in Form ZC as per the Shops and Establishment Act of Tamil Nadu. Okay, so previously we were submitting returns separately for minimum wages, maternity benefit, bonus, and contract labor. So all these rules and act has been repealed, and they have brought in one single code. So what happened? The government, state government of Tamil Nadu, they have notified that instead of going for all these different annual filings under different provisions, they have brought this annual returns filing under the Shops and Establishment Act, wherein the employer has to file the single unified returns in Form ZC, and this can be submitted every year on or before 31st of January. Okay, and this can be done digitally. They don't have to submit manually. They can submit digitally online. So this is a kind of ease of doing business. Okay. And IT self-certification. So people from IT and ITS establishment, the employee from IT and ITS establishment, they can go in for self-certification. They can declare in Form O saying that we are duly complying with the all the provisions under the Shop Act and the labor codes also. Okay, they can declare in this Form O, and this can be submitted twice in a year. Okay, for half year ending 30th June, they can submit on or before 31st of July, and for half year ending 31st of December, they can submit on or before 31st of January the succeeding year. Okay, so this notification, when we go through this notification, this was notified last October 2025. Why we have brought in here right now means to give a remind. This is kind of reminding all those employees from the IT establishments that they can go in for the self certification, which is due for the coming 31st July. So this is just to remind all those employees from the IT and ITS sector. Okay. And coming to Karnataka. So Karnataka, so persons who have enrolled at the professional tax, if they have remitted the professional tax for the whole year, means it is not mandatory for them to file a separate returns. So if they have remitted the tax, it is being deemed that they have filed the returns. Okay, so this is a what do you say, that a leniency given by the government. Okay, so it has reduced drastically, reduced the employers' work actually. It is a big relief for the employers. And Karnataka government, they also have introduced, notified the minimum wages, okay, effective from April 2026. So if you could see the shops and commercial establishment, I think you can see the notice, hopefully. Yeah. So you can see the minimum wage notification for the highly skilled workers for the shops and commercial establishment. This is for shops and commercial establishment. And people from other sectors, please, you can go and check in the government portal. They have given separately for each sector, for manufacturing sectors, for each different sectors, for scheduled list of employments. You can find out this notification in the portal. Yeah. So when you can receive this notification too. 1 minute. Yeah. So we have come to the end of this session. So hopefully this session is helpful for you. Before going in for question and answer session, I would like to have the feedback of this session from you all. So this will help us to understand how the session was very useful for you people. And this helps to create further future sessions also. So if you have anything to suggest on, please you can post that also. Please, you can participate all. I request all the participants to participate in this poll. This will give a valuable feedback from every one of you. So each one of your feedback is very valuable to us. So I request all the participants to participate in this feedback poll. And meanwhile, I request all the participants, if you have any questions, please post those questions in the chat box. Definitely we'll reply all those questions. And yeah, do you need any assistance? Yes. And please, I request that you can make use of the expertise of relativity in implementing this new labor code change. Currently, this is a hot happening right now. And you can make use of the expertise from relativity in implementing the wage code, restructuring the wages as per the new wage code, and the regulatory assessment, like for example, under the OSH code and IR industrial relations, wherein we have to look in for a few key changes in the industrial relations also. And OSH sector specific compliance, safety compliance is required for OSH code. So you can make utilize of the expertise here at relativity. Yeah, I request still few more people, they have to participate. See, as I told you, your feedback, whether it is positive or whatever it may be, this is helpful for us. We value each feedback. So I request all the participants to participate in giving this feedback so that it helps us to create further more sessions as per the participants' request. Okay. So you can keep on posting the questions. We have 10 minutes time. So I'll try my level best to answer all those questions with this 10 minute slot. If could not able to, definitely you can post through email also. We'll reply through email. Okay, so I think more number of people they have posted their questions in the chat box. Divya, is it over? Can we close this feedback poll?
Yes, ma'am.
Yeah, sure. Thank you. Okay, so coming to the chat. Okay, so I'm just opening the chat. I think hopefully everyone can see the chat also, right? Yeah. So this is from Ronald. Sorry. Okay. So the question is from Preeti. Our company registered office is in Mumbai and only the company director sits there, but operational office is in Noida, Uttar Pradesh. Please clarify in that case we will be covered in central rules. See, you have a locate office at Noida only, right? So you can comply with the UP rules. Okay. Ronald, is this applicable to private company as well? Yes, if your establishment is located in more than one state or union territories, you have to make sure that you comply with the central rules. Okay, and moreover, we have to look out for the state rules also for few of the key provisions, like for example, notifying the vacancies. We have to look out for the regional level notification also, and even for the e-commerce platforms, we have to look out for the regional state government notifications also. Vasanta, for temporary labor completes 1 year tenure, is he eligible for gratuity? See, this is a fixed term. You call it as a temporary labor, okay? But as per the act, it is a fixed term employee wherein all the benefits which is equivalent to permanent, they have to be provided. But yes, he is eligible for the gratuity. And I think Arun has already addressed. Yeah, and Annetta, on which website do we file Form 3 for gratuity? Please, you have to look out for the state government, okay? And Sushma, what about in case of 6 month contract and it was extended further one more 6 months? What is the rule for paying? Yes, obviously, if at the time of leaving the service, if he has completed 1 year service, gratuity has to be given. Is this applicable to private company as well? Ronald, your question is very vague. Please make sure that you keep posting the question should be very clear. So for that has help us to understand and quick give reply. Okay, ESA and gratuity. Yes, it is very much applicable. Is this for the female employees who does not have ESA? See, it is not there is no gender specific. Okay, it is applicable for everyone, whoever is falling into the purview of eligibility criteria. Secret and allowances are only for the factory or man. See, there is no discrimination of the establishment. Okay, whomever this crutch facility is applicable, they can go in for providing the crutch facility or they can opt for the crutch allowance. Okay. 50 women employee or employees. See, it speaks about persons, okay, not even employee. Okay, it doesn't even categorize the workforce as an employee worker. It's the persons. Okay, when you say persons, it is inclusive of the contract also. Divya, could you please clarify the treatment of gratuity when an employee leaves the organization before completing 5 years of service? Specifically, what should be done with the gratuity amount in such cases, whether it needs to be reversed, retained in the gratuity fund? I couldn't understand. Could you please clarify the treatment of gratuity when leaves the organization before? See, if he leaves the organization, not even completing 5 years, there is no eligibility for him to avail the benefit amount. Okay, so it all depends on internally how you handle the fund. Okay, Mukesh, please ask questions at the end of the class. Asking questions. Oh, sorry. Okay, from Premchand. Currently, our office is at Tidal Park building. I don't think Tidal management have a setup for crèche. Also, most of the married women employees works at home in office. Most of them are unmarried. Crèche facility doesn't serve a purpose at present for us. How do we comply? See, whether it is the employee, the employees or the workers are making use of the crèche facility or not, that is irrelevant. Okay, once the facility is being applicable based on the threshold limit, you have to provide for that. Making use of the facility is up to the employees to decide on, okay? But as an employer, you have to, it is a responsibility to provide the crèche facility. Okay, so our company registered office is in Mumbai and only the company, okay, I think we have already addressed this query. Is it compulsory? This is from a big company. This is it compulsory to report vacancy to exchange. Okay, if 20 or more employees are there, it is mandatory. Okay, it is not mandatory for you to select from the data pool. Okay, you can notify the vacancies, but you can select as per the company's, whoever fits into the requirement, you can select as per your wish. Okay, if we have already registered under the different portals, do we need to still register on the Shamsi? See, you can update. Okay, you can update your details. That's it. You don't have to keep going on registering. If you have already have the registration details, that is fair enough. Okay. Is it compulsory to report vacancy? I think we have already addressed this. If there is no crutch given by the employer, then can we compensate by? Yeah, you can go ahead. Manisha, we need to pay crutch allowance till child attends. Yes, exactly. And Ashok Sharma, thank you. Okay, thank you. Dinesh Shetty, could you please share the site? Yes, you will be provided with. Thank you, Yugandra. Thank you, Ananta Savi and Manisha Kost. Yeah, we need to pay crutch allowance till child. Yes, obviously. Saraswati, yeah, maybe please get a recording. Yeah, you'll be getting a record. Ponnamma, is there any minimum wages reference points to for specific to IT sector under Karnataka? Yes. Where can we refer the definition of skilled and unskilled? Please refer the Karnataka portal. Go in. There is a separate minimum wage notification for the ITS. You can download that. Please see, IT and ITS fall under the shops and establishment purview. You can refer that notification. Okay, if you don't find that any scheduled employment for ITES separately, you can very well refer to the Karnataka shops and establishment. Okay, and Ronald, is private firm eligible for all the compliance mentioned in the slide? Yes. See, there is no definition of private firm. You have to refer the definition of establishment. Okay, so that is the definition you have to refer to. And Ankush, maybe please, yes, you can get the file, presentation file. Thank you, Ananta Savi. You will get the details of Tamil Nadu notifications. And yes, Rodriguez is gratuity applicable for consultants who are not on the fixed term contracts. See, it is if it is what do you say, that freelancer means we have to think about that. If it is fixed term, yes, obviously. Manish Neman, is there still ceiling limit of 18,000 for PF under labor codes? Sorry, 1,800, sorry. See, we have to look in for the changes. Okay, as of now, please follow the current practice, whatever we are following with. I mean, we are adhering to. We have to look out for the changes. Okay, so whatever the practice you are following, please adhere to. Any specific changes in the state of Haryana means specific to what you are asking for? ESI should be calculated on basic. Yes, as per the revised wage, you have to. And kindly drop your email. Yes, you can. And are central rules applicable to companies which are located in Mumbai and have no additional office? See, you have to look out for the state rule. Okay, you have to look out for the Maharashtra rules. Rajaram Mehte, please advise, is it applicable to Maharashtra to pay crutch allowance if the facility is not given by the employee? Yes, it is not about crutch allowance is there. Okay, so we have to look out for the, suppose in case the state government is giving more allowance, notifying that you can provide 1,000 per case means obviously you would have to adhere to the state government notification. So that's why I have told that we have to look out for the notification for the crutch facility from the appropriate state government. Okay. Sushma, what about in case of 6 months contract and it was extended further? Yes, I think we have addressed that. Share the meeting. Yes, you will be getting. Is it mandatory? This is from Rajaram Maitri. Is it mandatory to obtain gratuity insurance? Yes, it is mandatory. Bharat, yeah, you will be getting the slides. And this was a very Karnataka and Tamil Nadu centric information. It would have been nice if other states like Maharashtra and would have been. Please, we have taken your valid point. We'll make sure that we cover these states too. Okay. So this is a valuable input. We will make sure we'll receive all those kinds of feedback. Okay. Many of our employees have requested to deduct ₹1,000 as PF since it has a significantly reduced take home. We have been so far deducting it at the rate of 12%, and we have restructured our CTC as per the please guide. Yeah, you can adhere to the ceiling limit. Okay. It will be very helpful if you could. Yes, you will be getting the PPT. Yes. Ashok Sharma, the employee who didn't have crutch firstly, they have to pay 500 per child per month is very less. What is the logic by this provision? See, that's what I'm saying. If the employer is very generous enough to provide more than this, it's welcome. Okay, no act will stop this. Okay, if the employer is very much willing to pay more than that, you are most welcome. Okay, so it is not that it is the minimum, at least the least minimum the employer can pay for that. So that is why the act has given this limit. Okay. And Anjali, okay, are the crutch related rules for all states? See, this is a guideline. Okay, so this is a central rule guideline. As I told you, we have to look out for the state level notifications too. Is it the great state level notifications more beneficial for the employees? Means we have to take the state level notifications. Yeah, and we have to look out for the notification. Yeah, you'll be getting all the PPTs. Know about crutch. Yeah, okay. And for gratuity payments for fixed term employees, should be strictly considered 365 days for of service, or can employees who have completed 240 days also can be considered? Yes, good question. So we have to look at the definition of the eligibility days. Okay, so we have to consider all the leave days, like as we do for the permanent employees. We have to take into considerations all the leave days. While at the time of exit, if they have completed 1 year of service, you have to look into all those details while finding out the eligibility. What is fixed term is less than 1 year? Yeah, it can be less than also 1 year. Santosh, for an organization operating across multiple states, which labor laws and regulations should be followed? The respective state rules and regulations are the central labor rules. In cases where the organization follows central rules, it may create ambiguity regarding the jurisdiction and authority of the state labor inspectors. Kindly clarify the applicable compliance requirements in such situations. So, as I told you, specifically in coming to, for social security, for few slides, you could see that a national emblem, meaning that you can adhere to the central rule provisions. And few slides, you could see that other than the state provisions rules, you have to adhere to the state provisions. So once the state rule provisions or state rule has been notified, we may have to adhere to the state provisions. As I told you in the earlier beginning itself, so for whom all the state central rule is applicable, has been clearly mentioned that the banking sector, telecom, insurance, all these fall under the purview of the central government. Appropriate government is central, and those establishments which is actually located more than one state, they have to adhere to the central rules. Okay, even then, when you go in depth, we could see that if you have a regional notification carry centers, means you have to adhere to the regional carry centers notification of vacancies. Okay. Abhishek, okay. Sorry, I have scrolled. Yes. Please suggest if we can also go ahead and process payment of gratuity amounts on pro rata basis for our regular employees. Though a regular employee qualifies for gratuity after 5 years. See, are you going to pay the employees even before they have become eligible for gratuity? Your question is very vague actually. If that is, if you're asking whether we can pay right away even before the completion of 5 year service, not advisable. Okay. Your question is quite vague. I need to understand. Okay. So Manish Neeman, do we need to pay crutch allowance till? Yes, we have to pay up to age 6. Neelam, know the difference between act of premises registration. No, I don't understand. Neelam, your question is not very clear. Okay. If Jodi, if we have already registered under the different portals, yeah, I think we have addressed this. Please explain from Chandru. Please explain ESIC applicable only basic salary. It's not that basic salary, wages. Okay. Neelam, could you please explain when Factory Act applicable for the company? See, the Factory Act is fall under the purview of the labor code. Okay, so still rules has to be notified for the state. Okay, so we have to wait for the state rules. So once that state rule has been notified, means the appropriate labor code. I'm saying it is not the factory rules. I'm saying it's appropriate. Labor code state rules has to be notified. Till such time, please adhere to the factory rules. Okay. Chandru, I think I have already addressed. Is the trainee or also being considered as an employee? No, no. For the ESIC, no. Okay. Fiona, is gratuity applicable for consultants who are not in the fixed term contract? No. Can we, Jodi, can we compensate by giving crutch allowances without having facility? Yeah, you can. Right. What about ESIC wage calculation? Yes, you have to redefine the wage as per the new labor code. So as per the new redefinition, you have to go in for finding out whether the employee is eligible for the ESIC provisions. Okay. Yeah, thank you, Purnama. And Sushma, we have offices in Mumbai, Delhi, and Karnataka. Then which rule we have to follow? See, as I told you, central rules. Okay, and please look out for few provisions. It has been advised to take care of the state rule provisions also. So once the rules has been rolled out, we may get to know more clarity on that. Yeah, you will be getting the session, okay, PPTs. You'll know about contractual employees law regarding benefits they can get. Yeah, we can have a separate session for all that, okay. Kothrish, applicable date for gratuity to fix a term of contract employees. Yeah, at the time of exit, no, if they have completed 1 year of service, you can provide the gratuity. Yeah, Panama, you will get all those recordings. Thank you, Vasanta. Is CTC valid under the labor law? See, CTC is some term which nowhere you can find in the labor code. Okay, no such term. Vaidyanathan, thank you. Nikita, if we hire freshers and they exempt PF under Form 11 upon having their basic TNA more than 50, so in future, after a few months, they opt for PF contribution, then which date to consider as date of joining on PF portal record earlier on the date from which they want to opt in. See, we have to look out for the notifications. Okay, so date of joining on PF portal date from opt-in. Okay, our company is facing, this is from KK, our company is facing a high attrition. With this background, please suggest if management decides to implement payment of gratuity amounts on completion of minimum of 1 year of. See, I think you are confusing. The regular employment is different. For regular employment, it is for the 5 years period of completion of service. Only for the fixed term employment contract, wherein the contract is for the limited period. Okay, for example, it can be 6 months or 1 year. Okay. Okay, is gratuity applicable to consultants who are not on fixed term contracts? Yes, I think I have already answered this. Indrani, if a company is in Karnataka and work from home employees are there in several states, does new labor provides which ESA, gratuity or other regulations on has to follow? Okay, so good question. So wherever the establishment is registered with, they have to adhere to. Okay, so ESI provisions they can avail wherever, whether from home state or in the working state, in the Karnataka, they can. Okay. I think I have addressed all the questions. If you still have any questions, you can post in the your mail. Okay, so we are very much active in all the social platforms. You can get connected in LinkedIn, YouTube, and we have a blog also. Okay, so thank you all. Thank you so much. Divya, we can wind up. Yeah, thank you.